So our second snippet for this week is going to look at one element of constitutional history during the Wilson administration. Woodrow Wilson, elected in 1912, will serve 2 terms, is a progressive-oriented Democrat, but has positions that in many ways we would now associate with on the right. One of the things to remember, I was mentioning in the first snippet, in pointing out that the Supreme Court and its decisions were becoming increasingly controversial politically. One effect of this is to make Supreme Court nominations more controversial in and of themselves. And so Wilson gets 3 Supreme Court nominations and tries to shape the court in his direction. It's not, he does not entirely, does not largely succeed. His first is his Attorney General, James Mcreynolds, who had a background as kind of populist Democrat. Mcreynolds winds up a very, very conservative justice. This is a name to keep in the back of your mind, because we'll cover him again in the 1930s. But that wasn't Wilson's expectation. The idea was that this is a guy who seemed to have populist credentials. He would push the court in an anti-business direction. And then in the election of 1916, Wilson is running for re-election, but is an underdog for much of that contest, is trying to appeal to voters on his left, voters who voted for the Socialist Party candidate in 1912. The Socialists got 6% in the 1912 election. They're not contesting the 16 election as much, and Wilson thinks that maybe he can win some of them over. And the result, there are 2 vacancies in 1916, and Wilson nominates probably the 2 most left-wing Supreme Court nominees until that point in American history. Louis Brandeis, remember we saw him from the Brandeis Brief and Muller, and John Hesson Clark, who was a sort of progressive activist from Ohio. Both of them get confirmed, although the Brandeis confirmation is a very difficult fight. Conservatives in both parties don't like Brandeis's political philosophy. They also don't like the fact that he's Jewish. He's the first Jewish Supreme Court nominee in American history. And ironically, he gets confirmed thanks to the votes of Southern segregationists, many of whom are anti-Semitic, but who Wilson lobbies on grounds that they have a kind of obligation to back the party line. So there's a more progressive, small p progressive court. Nonetheless, on civil liberties, this really is not much of a court, and you can see it in a series of cases that deal with obscenity and free speech. And the backdrop to this is a law that's passed in 1873 called the Comstock Act, which is the first federal obscenity statute in American history, and it gives all kinds of power to the federal government, chiefly to the Postmaster General, to regulate the spreading of material that's seen as obscene, and this is a criminal statute, and so people who violate this law can be sent to jail for between 6 months and 5 years. So it's really quite serious law. In today's First Amendment jurisprudence, anything like this would be seen as unconstitutional, because it's so broad in terms of its scopes. But this is a Supreme Court that is open to the idea that it's appropriate for the government to actively regulate, to promote a kind of public morality, and that includes Justice Holmes. Remember, we saw Holmes was an opponent of Lochner, so he's not a big fan of a kind of conservative economic area, but on social questions, Holmes, is willing to give the government great leeway. There are a couple of important decisions from this period, one of which predates Wilson's presidency. This case called Patterson versus Colorado. It dealt with a case in Colorado in which the judge was concerned that local media coverage was potentially inflaming the jury, and issued a contempt order telling the local newspaper that they couldn't write what they were writing about the case. This seems like a pretty obvious violation of the First Amendment. But the Supreme Court upholds the Colorado action on grounds that there's a more important principle at stake here than freedom of the press. It's the sanctity of the system of trials. This is not a robust decision for press freedom, but this idea of a trade-off in terms where freedom of the press or freedom of speech is balanced against some other principle that supposedly promotes the common good. This is very much a hallmark of progressive era First Amendment jurisprudence. And we see it in this case out of Washington, dealing with a publication called The Nude and the Prudes, which was designed as a challenge to Washington State's obscenity statute. So it was it's this idea of challenging the article was seen as obscene, and the case eventually works its way up to the Supreme Court. And in the case is called Fox versus Washington, the court upholds the Washington obscenity laws. Admits that this is a kind of satirical piece designed to just to sort of say how absurd these laws are. But the court says, look, let's give states the benefit of the doubt in this first sentence here when they want to enact laws that might suppress unpopular opinions. Here, the disrespect for the law that was encouraged was a disregard of it, an overt breach and technically criminal act. So, the idea of disrespecting the law as a criminal act is, we would not associate this with a kind of progressive vision, but in the progressive era, the idea is that it's okay to give the government the benefit of the doubt in terms of shaping opinion. You see this in one of the progressive era amendments, and it deals with the sale and dissemination of alcohol. This is a contemporaneous map which shows the situation in the United States in the early 20th century. And one of the things you see is that there's a great variety between states. So the states that are in white here are states that have an absolute prohibition on the sale or dissemination of alcohol. The states that are in checkered give that authority to localities, and the states that are in black, wonderfully identified at the map, and this is from the 19 teens, as booze states are Nevada, Pennsylvania, and New Jersey, states that have no restriction on the sale or dissemination of alcohol. And the concern here is that among prohibitionists is that as long as there are some states that allow for the sale of alcohol, that will easily bleed into the states that are seeking to prohibit. In 1913, Congress passes a law called the Webb-Kenyon Act, which makes it a crime to ship or transport alcohol across state lines into a state where into a dry state, a state where the sale or dissemination of alcohol is prohibited. But this is a law which is really, really hard to enforce. And what turns out to be the key development in what becomes the 18th Amendment, the Prohibition Amendment, is World War I. First of all, there's this sense, like with Budweiser, that beer is somehow German, and so it's a nativist approach. And then secondly, there's a sense that a system in which we have these young boys, 18-year-olds who are being drafted, they're being sent off to war, and they're vulnerable in the progressive prohibitionist discourse because the saloon people will be right near the military bases and get them drunk, and then they'll sleep with women, and it's a kind of morality tale that's gone on here, but it's very, very popular. And prohibition is seen as patriotic. And the result is the passage of the 18th Amendment, which gives Congress the authority to outlaw this nationwide the sale or dissemination of alcohol. This, of course, is the only amendment that is ever repealed. The other constitutional amendment from this period, and the last of the Progressive era constitutional amendments, is the Suffrage Amendment. And much like Prohibition, suffrage was a situation that varied very much by state in the 19 teens. So all of the states that are in green are states where women could vote on all matters. Then there are a handful of states where women can vote in presidential elections, but not in local elections. And then there are a handful of states where women are allowed to vote in local elections, especially in school board elections. And the idea is that women as mothers have a particular interest in school matters. And then there are a couple of states where women have no right to vote at all. This is a difficult fight for the suffrage movement, in part because Wilson, who is no prize on racial issues, to put it mildly, is also not particularly supportive of the idea of women's suffrage. There is a sense that allowing women to vote, the idea, it's a kind of oddly sexist argument that's underlying at least part of the suffrage movement. The idea is that women are more moral, more principled, and so if they enter the electorate, that will create a more tempered electorate. It turns out that giving women the vote produces almost no political change in 1920, but that's not the sense at the time. Ultimately, these kind of public protests, you have women college graduates who chain themselves to the fence outside the White House. They attract a lot of attention. They're very sympathetic, and ultimately the movement succeeds. Although there is a division within the movement. For many longtime advocates of suffrage, that's the end of the movement. The argument is that the goal of a kind of feminist political discourse was to ensure that women have equal political rights through the right to vote. But there's a younger, more radical wing of the feminist movement in the Progressive era, focused around this woman, Alice Paul, who's head of an organization called the National Women's Party, which says that political equality isn't enough. You need absolute legal equality as well. And Paul comes up with the idea of an equal rights amendment to the Constitution. And this, of course, is an issue that we'll be coming back to several times throughout the course. So there is some division in this question as whether or not suffrage is enough.